We've got Attorney Extraordinary Benton Ross Watson, and last week we've been doing the amendments, and we're on 6, but 6 was so chock full of nuts here.
Man, we had so much to do last time, and this was my favorite amendments. But as you know, my favorite is the 4th and the 1st, maybe one. But man, these are 6 is very important. Like I said, it's the criminal defense trial lawyer's tackle box.
That's right.
Okay, and it's very important. If you're going to be in the criminal defense business, you got to know your 6th Amendment. And we've got a lot of fun cases, a lot of important things that you guys should know. And I hope to demonstrate today from what I was talking about at the very beginning. I said, if you listen to this series, you'll see that each one of these constitutional amendments is a hodgepodge. They each work together, each intertwined, right, to protect the other. And so let's get to it. So, I mean, today is the 6th Amendment. To recap, and last time I broke the 6th Amendment down into 5 pieces, but really it's more than that. But we're going to talk about probably the 3 most important, in my opinion, the ones that I think everybody can relate to today. The 6th Amendment says, though, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district where the crime has been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. And so today I want to focus on really the importance of the jury trial, the importance of cross-examination, right to confront your witnesses, and the right to have a lawyer by your side throughout those proceedings. You remember we spoke, I got to tell the story last week about how even when the right to an attorney is so important to the assertion of all these other rights, and that's how we exercise these other rights, that even when a case might result in, may end in a horrendous, I'd say even atrocious result, courts are not only willing but mandated to throw it aside, to stonewall that prosecution. And even when it, like we said, resulted in a murder of a young girl. Yeah. Okay? And so that's how important the right to counsel is. And just to tell, oh, by the way, so that brings me, one of my favorite professors of all time, he's probably one of the best, many other students would agree with me, Jeffrey Korn, Professor Korn, expert in law of war and counterterrorism tactics, was a highfalutin, I call him JAG attorney for the prosecution, actually. Listened to our show. He said he would kind of want to join, but he sent me an article that was very interesting about, is actually the 5th Amendment, about the interrogation tactics. And I'm not going to get so much into that, but he made his case that he wants law enforcement to tell people that they have the right to remain silent. Not only that, but that their silence cannot be used against them. Their silence, right, will not be evidence against them. Their silence will not be used as a coercive tool as a sign of guilt, in other words. And so he wants an additional warning for the Miranda. And he makes his case by saying that the reason that we warn people about the right to counsel is because they don't know any better. They may be commonly and logically smart, but they're not legally smart. And they're subject to manipulation, to coercion, to just the environment, the adverse environment. People are not used to that. And I can tell you as a defense attorney, just be quiet. Like, don't say anything and use that right. But it was so important. An attorney will tell you that. And so that just goes to show that how important that an attorney is. And if you think about it, when we started out in the England days, we had secret examinations. This goes into cross-examination of the witnesses. And I'm going to spill over a little bit into these because they're all kind of the same. They're protecting the same rights, okay? And so it would just be magistrates questioning witnesses in secret, and then you'd go to trial, and then have, affidavits that you couldn't cross-examine, and they didn't allow you to have a lawyer.
Who would put up with that?
And it slowly evolved.
I'm surprised excuse me. I'm surprised it slowly evolved and didn't have an uprising and say forget this.
Well, it did. So the story about Sir Walter Raleigh,
Yes.
and so he was accused of conspiring to murder the king, assassinate the king, and his co-conspirator simply testified in an affidavit, and he demanded that they give him the right to face his accuser and show him who it was and allow him to question, and so that he could further develop the case, and they didn't, and he was convicted. He was kind of in a pardoned in such a way, so he wasn't put to death at that time, but it really that's kind of was motivation for the founders to say, man, we don't want this. And it goes all the way back to Roman and Hebrew law. I think one of the Roman rulers, when the Apostle Paul, I think I got this one written down here, said that it is not the custom of the Romans to deliver a man to destruction before the accused meets the accusers face to face. And it just goes to show that you have to be able to do this, but how are you going to cross-examine yourself? Think about it. You think about the right to testify. You think about the right to testify. A lot of people say, well, if they don't testify, that means they're guilty. There's actually statistics showing that if you testify, it's probably more likely that you're going to be convicted.
Because you're doing something wrong.
Yeah.
You're setting yourself up when really you didn't have to, whereas being quiet, it's done in a more logical method from your attorney. It's making sure that all the I's are dotted and T's are crossed as compared to just spitting stuff out there and you didn't mean to say it, but once you say it, it's too late, it's out there in the public, right?
And two, yeah, and we ask jurors all the time, so why are some reasons that somebody wouldn't testify? Maybe they have a speech impediment. Maybe they're overly nervous. Maybe they're just not that smart. Maybe they just get really super nervous. Maybe there's tons of reasons why somebody would not. Maybe they feel like they're fat.
That's ridiculous.
I'm serious. People are ridiculous.
So then where do you draw the line when it comes to making someone testify or saying, if you don't testify, we're going to lock you up because you're...
And so that's where the Fifth Amendment comes into play, right? It's you cannot be compelled to testify, right? And the prosecution is not able to comment on that either, okay? But all of these things work together, and so you have to be able to use these rights. And so in the colonial days, when they gave attorneys the right to cross-examine, this transformed the practice. So it went from us not being able to argue, us not being able to do anything, a judge controlling the entire trial, basically. And even when they had the right to a jury trial, the judge would have the right to cross-examine. The judge would make the rules. The judge really didn't give the jury as much weight as far as fact-finding. In other words, when the judges determined certain facts, the jury couldn't second-guess that. They had to go with what he said. And so, and when they gave attorneys the right to start just cross-examining, it completely transformed, right, the whole structure of our judicial practice. And so going from there, that goes to the jury trial. And I always talk to the jurors. If you're listening today, if you get your jury notice, man, it's an honor. It really is, and we appreciate you being there. And I know that sometimes it can be an inconvenience, but really take pride in getting that notice and showing up and doing that civic duty. And it goes back to the reasons that they said in Duncan versus Louisiana. It's a Supreme Court case from 1968. And it asked, why do we have the right to a jury trial? And the court answered that question. Right to trial by jury is granted to prevent oppression by government. It represents that inestimable safeguard against the corrupt or overzealous prosecutor and the compliant, biased, or eccentric judge. It reflects a reluctance to entrust powers over life and liberty to a group of government officials. And it concerns fear of unchecked power, and the deep commitment of the nation to the right of jury trial as a defense against arbitrary law enforcement. And this goes straight to the heart of, you guys are going to be told if you ever serve on a jury that you don't have the right to ignore the law, that you must follow the law in every instance, and that you have to follow it and just basically apply it to those facts, or the facts to the law in certain cases. And so I want to tell you that you absolutely have a right to disregard the law.
Let's go over that.
You absolutely have a right to nullify. There's been cases after cases after cases. Duncan's one of them. There's other very persuasive federal court opinions that talk about sometimes the juries were the only reason that blacks, right, didn't get convicted of things. They stonewalled certain prosecutions because it was just a wrong case. And if they had to follow the law in the case, maybe they would have convicted them, but it was not right. And so you absolutely have the right to nullify, and that's nullify the law. You have a right to ignore it. They're not going to tell you that at trial, okay, because they want you to fall within their certain little elements. And hey, as a defense lawyer, if I'm arguing a self-defense claim, right, I'm probably going to say the same thing.
I don't understand why you, as an attorney, can say that, but the court won't tell the jurors that.
We can't tell them either. We'd probably get held in contempt here for doing that. But yeah, I mean, you can't. No one can tell them. But I'm not in court today, so
I don't get that, man. That's just not right.
Yeah, and you're not. The state's not going to be able to appeal that. They're not going to be able to overturn that. If you decide that you're not going to convict in this case, regardless of what the law is, and that's what I spoke to Rick with in our session. We spoke about the grand jury. And so the importance of the grand jury in the day of the founding would have been the grand jury, the local grand jury pulled from the nearby location would know the fashions of the times and what's going on. You don't want a bunch of people from Pennsylvania deciding a bunch of things in Florida. Okay? And so if they felt like a law from England or a law that was maybe applied nationally, or not nationally at that time, it was different colonies, but from Parliament, that they felt like was unfair to apply in those local colonies, they'd no bill it.
I have a question.
Same thing with the jury.
I want your opinion on something. Do you think the jury is swayed more by the facts, more by the person being the defendant, or by the attorney? Does the attorney have charisma that draws the jury into saying, I like it, I'm going to follow him just because he's good at it? Or they look at the defendant, they're saying, I can't believe this person would do that, and the way they're talking, it just doesn't fit them, or something else. What is it?
A lot of lawyers are going to tell you that you got to be likable. You got to have the jury like you. I think that regardless of what that opinion is, you've got to be able to have the jury listen to you. As long as you can have the jury listen to you and hear your side of the story and accept that, okay, then I think that you're doing a good job as an attorney.
And the reason I said that was what you just said here. The jury doesn't have to go make a decision based on what the law is. So if they're like digging the defense attorney, and the guy, let's just say he's guilty of sin, but they like the defense attorney, and say, he did a good case, we like him, he handled himself good. There might be some questions, but what the hell? We'll just let the guy go.
Well, I'll tell you this story. I don't mean to toot my horn, but I think it illustrates it, and it's not really. It's kind of both ways. But after I got a not guilty in a jury trial, I was walking out. One of the jurors said, Mr. Watson, man, I just want to tell you, man, nobody liked you. You're a complete beep, and man, I can't stand you either, but you're the best lawyer I've ever seen. And I'm not the best lawyer out there. I'm just saying, nobody liked me on that jury, but the point was they all listened to what we had to say. And it wasn't a case where it was easy to be nice, and so I can understand why they might have felt like I was being overzealous at times, but it's just, you gotta, I think that when you say, do you want jurors, are jurors going to listen to the facts, or are they going to listen to, technical stuff, are they going to listen to the law? A lot of times that depends on the case. A lot of times I'm gonna want that guy who's very analytical. I'm gonna want that guy that's gonna look into everything, read between the lines. In another case, I'm gonna want the guy that is not really there half the time, but doesn't really care.
You bring up a great point, because I teach that too. I teach personalities, I teach body language, all these different factors. So if you get like a personality who's a sanguine, the last thing they want to hear is detailed facts. They just want an overview of what's going on in a happy manner because they want to be happy. But you get a choleric, I believe it's phlegmatic, who wants the details, is here for business and wants detail after detail. You, the attorney, giving him a flighty type of bit of information, he's going to go, I can't deal with this guy. He's going to listen to the guy who's giving him facts, you know?
Right, exactly. I mean, that's exactly it. And so you want, my point is, you want somebody that's going to listen to your side of the story. And I don't know if it was last week or with Rick, when I used to work with Clyde Chandler, a lot of times my favorite thing he would say is like, I'm not here to pick a fair jury. I'm here to pick somebody who's going to listen to my side of the story. Yeah. Okay, and so that's really true, right? So we're going to pick the jurors that we like, okay, and other attorneys will tell you, no, you don't pick, you deselect the bad ones. Clyde would tell you, I'm going to pick the jurors I like, and I'm going to make the state try to get them off, and hopefully I can make sure I got enough of the people that I wanted.
Is it hard for you to do a case knowing somebody's guilty, but making sure that they get every right that they're still allowed?
I haven't had a case that has done that to me yet, but I can see. One case, my first jury trial, I got not guilty. I don't know how I did it. It was on a traffic ticket. He was driving while license invalid, and they had him on tape driving with no license, and the cop already knew he didn't have a license because he stopped him the day before. He's like, I was like, man, you need to take a plea deal, man. We need to plea this out. I don't even know how we're gonna win. No, man, no, we're gonna fight this. I was upset. I was like, man, you're wasting our time. It was not guilty. After that one, it was a wake-up call that, man, exercise your right. And so, I haven't had a case that touched me emotionally yet. I'm sure there would be some that would.
The only thing that would make me, if I was an attorney, I come from a family of attorneys. I got attorneys all around me, so I've got that attorney atmosphere in my brain, okay? But based on what you said about the girl who got murdered, but you got to maintain the laws, I think that's how I would apply it. It says, if I'm a public attorney for somebody who can't afford their own attorney and I've got to defend his rights or her rights, I would look at it in one way only, and that is, I know you're lying, I know you're crooked, I know you're guilty, whatever, but I'm sworn to make sure at least you get your rights so that you can be convicted legally. Would that be a fair statement?
Yes, and so that's the way I look at it too. And 1 John 2:1, we're all entitled to an advocate. Yes. Okay, who am I to judge? We all have an advocate in Him, and so when we talk about, my job is not to get you off. My job is to make sure that the government follows its procedure. Okay, my job is to make sure that the government follows the process like it's supposed to be done. Now, hopefully, I want to make money and I want to be in business and I love what I do, and so hopefully I want to be better than the next attorney. Okay, so sometimes that drives me to want to win. Okay, but at the same time, it's an adversarial process, so you can't have somebody that's not a competitor. Okay,
yeah, but staying honest to yourself and still being competitive, that's the way to do it.
Correct, but just like any athlete, you gotta have the integrity when you're competing. And so, I don't want to run out of time here, but I do want to talk some more about the confrontation clause. There's some interesting stuff, and I'll tell you, it's a fun case. Crawford versus Washington was one of the big ones, and it was where two guys basically got into a fight, and one gentleman ended up stabbing the other guy, and they ended up taking him to trial. And his wife was at the scene, and when the cops show up, they questioned his wife. And his wife, they got her on tape. And so when they went to trial, it was his wife, and he claimed what we talked about on the show already, the spousal communication privilege. He, the defendant, prevented his wife from getting on the stand and saying what she had said, because it was contradictory to his self-defense claim. He was claiming self-defense, and what she said is, oh, he started it. Okay? The Supreme Court said that they could not, and so let me finish. And so what they did is they got the police officer to come up and play that videotape. And it was her testimony on that videotape saying that, no, he started it, and so he couldn't use that self-defense claim.
Right.
And it raises a whole new, not a new idea. It goes, it was historical. Justice Scalia wrote that opinion. It was based totally on history. That's why he overturned this case. But can you imagine why this was overturned? A lot of people were upset about this. especially from the state, because well, it's a recording. It's a recorded video. Why can't they play that? Because nobody had the right to cross-examine the wife. Neither did the defendant. Even though he prevented her from testifying, he still did not have the right to cross-examine her the time that she made that tape. And because she was unavailable and there was no right to cross-examine, and it was what we would call testimonial, in other words, it was within the confines of an interrogation made for the purposes of criminal prosecution. The police were talking to her, right, for the purposes of bringing a charge. It was a testimonial statement that the defendant had no right to cross-examine the witness for. And so it's very strong. I mean, this of all the constitutional rights, and that's why I love the Sixth Amendment, these are the ones, right, that I still feel like have some teeth. Fourth Amendment's basically useless now. First Amendment's very strong in some cases, but not in others. It's lost some of its teeth. Even Professor Korn argues about how many exceptions that they've made to the Miranda requirement, and actually it supports police now instead of protecting defendants like it was supposed to do. And you know that we talked about the Second Amendment. Obviously, it wasn't incorporated, and we didn't have a lot of cases on that at the time. But it's always being litigated. There's always cases finding exceptions for this, and it's just the government slowly chewing away. Mm-hmm. And so, by the way, it's not all Professor Corns, but he probably disagrees with me on some of the Fourth Amendment stuff. Being a prosecutor of the state, yeah. Oh man, you don't even understand. Man, you would want to do the show anymore. That's how good he is. But we need these rights, and these Sixth Amendment rights are still ones that have stuck around, and they're still as strong today, if not stronger than ever. Except there's, and this applies too. We're gonna see. You'll see some of the, like, if you got to get you on a DWI case, I'm gonna hope that they try to submit an affidavit, right? Just like they did. We're doing in England and in the early colonial days. Yeah. Submit an affidavit, right, saying that your blood alcohol is such, when that person is nowhere to be found to cross-examine. Okay? Mm-hmm. And so all this drives the prosecutors crazy, because it's hard for them to try to get all of these expert witnesses from around the state to come here. But they've got to. And it only makes sense because I promise you, those lab techs, there has been many that have been, when I say many, I don't want to say many, but there has been a lot of cases that have been overturned because of just not neglect, but intentional wrongfulness on the part of the state lab tech, or and there's also been we tried a case here on the manslaughter DWI, and the blood wasn't even the right blood, and so and we would not have known that had we not, right, taken that case to trial. Even though we had an idea about that beforehand, there would have been no way for us to show that if we would not have gotten the person. So it's not just reliability. It's not just reliability of that evidence, like science evidence. It's the manner in the way that it's presented. And that's why you need a lawyer. And so don't talk to the police. Get a lawyer. I mean, I'm not saying get me. Just get somebody before you go talk to them. Because I promise, and I talk about one of my really good friends. I say she works for the sheriff's department. Really bitty, cute as a bug Mexican girl. Goes all around, everywhere. Goes way out in the woods, talking to tweakers, right, and all by herself. Has no backup. Gosh, I admire. I'd be like, man, I don't want to go here by myself, right? And she goes, I know how to talk to people.
That's a good thing, yeah. It's a good thing to know.
Police officers know how to talk to people, and so they're gonna know how to ask you questions.
They do?
Well, they know how to interrogate people.
That's probably better.
And so it's like when you said, so, did you smile when you slapped your mom in the face? Well, how are you going to answer that question? I mean, it assumes you did it.
No, I didn't smile. Oh, so you did it. Yeah, I do smile. Oh, you did it.
You know, they're good at those questions. Okay, and they're good. And I'm not saying they're crooked or something like that. They're doing their job. They're doing their good. That's fine. Right? But you need to be aware of your rights. And so, because sometimes, I'm telling you, sometimes innocent people say dumb stuff, man. I can testify we've had innocent people that have been charged. They've gone through the rigors of prosecution, and then we've come back, right, and undone the case. Okay, we've gone all the way to a couple days before trial, and it comes out, we find out something else. But everybody knew they were guilty because they said stupid stuff. And I promise you this stuff happened.
So what I've learned so far is that it doesn't matter what happens in the courtroom, the jury can override it, and always use the fifth so I don't get myself in trouble.
Always use the fifth. Not a fifth, but the fifth. Yes, always be aware of the Fifth Amendment. Make sure you don't sleep on that right and your Sixth Amendment right to an attorney. Okay, there's so many good cases I could have went into, but we just didn't have the time. But I wanted to convey and stress the importance of using your rights in the judicial system. Without the First Amendment, your lawyers wouldn't be able to speak. Without the Sixth Amendment, you wouldn't be able to assert the First Amendment. Without the Fifth Amendment, they could just put you in there and make you testify against yourself, even if you couldn't otherwise do it and you had no representation. I mean, without the Fourth, they could get your papers and use that against you. Okay, all of these things are intertwined, and hopefully, if we get anything from the show, it's to try to. Some changes are good, but other changes I feel like have gone too far. Like there's one exception to the confrontation clause rule that I don't like, and a lot of people disagree with me, but it's in like a child sexual assault case. Okay, they don't. A lot of times courts won't make them be face to face when they testify, and I feel like, man, I get it. I understand your argument, but man, kids lie, man. Kids make stuff up. Kids, I've used a child from the defense standpoint to win a case, okay? And they're powerful. They're powerful. And so it's like, man, they put them up there, but they do lie, man. And for some reason, people think they don't.
Yeah, they do. They do for sure.
And so, respect the right to have the crucible of cross-examination. Always exercise your right to a lawyer, and be proud to stand on a jury.
You know, kids younger and younger are getting more smart, more savvy as to how the world works because of that electronic device that they have.
Oh, absolutely.
And so when they see all this stuff going on, it's almost, in my opinion, in my observation, it becomes almost like a game to them. How far can I pull the truth or stretch the truth to get what I want, or just to mess things up or shake it up or be the highlight of the day?
But man, I promise you, I don't just do criminal defense work. I do family law cases too. I do guardianship type of cases. They are they're not always lying. Man, kids are so susceptible to manipulation. And eyewitness testimony is the most, or at least one of the top three most unreliable pieces of evidence there is. And that's why it's important to have the right to cross-examine, examine somebody's memory. Did they really see what they think they're remembering? Okay, I can tell you so many cases of several Justice League type of organizations, that innocence projects and things like that have gotten cases overturned based on eyewitness testimony.
Is that just one individual? If you got two or three saying the same thing, then you're pretty much...
It's not always limited to one witness. But obviously, there's going to be some things that, if you got two or three witnesses that remember one aspect, but...
To draw the guns back into this, when I teach my license to carry class, speaking of which, ladies and gentlemen, I got a class at 2 o'clock. I got a couple spots open if you want to participate and give me a call to show here, 254-697-6633. But when I'm teaching the class, I'm telling people, look, somebody breaks in your house at 3 o'clock in the morning, you shoot them in the living room, they're bleeding out on your floor, the police are going to come, they're going to ask you questions, but you're probably going to have the option if you want to sleep in your room that night or get a hotel room, right? Right. But if you're on the corner of 5th and Main, and you do the same thing and you hold your ground, because it's a castle doctrine where you can hold your ground, you no longer have to run, you can stand your ground, and you shoot somebody there on the corner of 5th and Main, there's 10 other witnesses, and each one has a different vantage point. What you say may be a little bit different from each one of the witnesses who sees it. So a verbal or eyewitness account can actually be not as accurate as you think it would be.
Correct. And so, I mean, it doesn't help you always to have... Yeah. And they're seeing it from a different vantage point.
That's why I'm saying the whole purpose of that illustration was, if you're going to pull it out, make sure you have a darn good reason to be doing it.
and too, they may not have, if they're not in the vicinity that you're in, they may not have felt that it was that threatening of an issue. Mm-hmm. A lot of times people think that they're better than other people, and that was unreasonable. and they were in that situation, they probably would have done the same thing. A lot of times it's hard to try to convey that to people. So even though I have represented guilty people, sometimes I just feel like the prosecution's overreaching, or man, yeah, maybe they violated technically, but man, this was a tough set of facts for anybody.
Okay, we're just about out of time. Anything else you want to go over real quick? Because what we're going to do, we're basically doing this numerically, 1 through 10. However, Rick shows a lot of passion and favoritism. He wants to do the 7th Amendment, but I'm not sure of his schedule. So you may be doing the 8th next week if you're around.
Okay.
It just all depends on what's going on. But do you have
I'm ready.
Do you have anything left for this one? Any final words, parting words?
Again, don't sleep on the 5th. Okay, just don't sleep with a 5th.
Yeah.
But exercise those rights. Serve on a jury. Take pride in it, man. And if you feel uncomfortable, really, I would recommend you getting a lawyer anyway. But there was a DWI stop. Some lady said, "I want to talk to my lawyer, Clyde Chandler," and then she fell out. I never said, man, that was great. But no matter what situation you're in, even if it feels uncomfortable for you, make sure you assert that right to a lawyer. Police questioning will stop. And man, always make sure that you're able to confront the witness. Always have that option open. So,
I was noticing a card here. It's I don't know what this is for, but it's City of Rockdale Get Out of Jail Free card. I'll show it to you in the camera.
That's not mine.
I mean, where the heck did this come from? It's a Monopoly card. Anyway, okay. Tell them how they get a hold of you. Tell them about Rick. Respect for you, the whole rest.
Oh yeah, respectforyou.com. Rick Dodd, thanks for sponsoring this show. If you got anything that shows lack of respect for you by injuring your person or violating your liberties, especially some of the things we've been talking about today, you can holler at me or Rick. My number is 254-605-4140. Really, we love calls about the show. That's why I do this. I love getting the word out. And so we get a lot of emails. If you do email me, make sure you leave your phone number. My email is benton@watson.legal. That's benton@watson.legal. You can come holler at me at 105 East Main Street here in Cameron. Big Milk on the side. Can't miss it.
Sounds great.